Welcome back to one more session. Today in this video I am going to explain about essentials of a valid contract. All agreements are not enforceable by law. Therefore, all agreements are not contracts. Only those agreements that fulfill the requirement prescribed under section 10 of the Indian Contract Act become contracts. What is section 10? Section 10 says that what agreements are contracts. According to Section 10 of the Indian Contract Act, all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in India, and not hereby expressly repelled, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to the registration of documents. This was given under section 10 of the Indian Contract Act. According to that, as per the definition in section 10, an agreement to become contract must fulfill some requirements, that are consents addendum, which means meeting of minds of the parties. Parties are said to be consent when they agree upon the same thing in the same sense. For example, Venkatesh offers to sell his 200 square feet plot situated at Jubilee Hills, Hyderabad to Nagarjuna for 50 lakhs. Nagarjuna assumes that the flat is located at Banjara Hills in Hyderabad. Since there is no consensus, there cannot be a contract. And another requirement is free consent. The consent of the parties is said to be free. It should not involve coercion, undue influence, fraud, misrepresentation, or mistake. And another requirement is competency of the parties. Sections 11 and 12 of the Indian Contract Act deals with these elements. One who is the sound mind and is measure is competent to enter into a contract. Any of the other factors like minority, lunatic, or drunkenness may render the parties incompetent. Another requirement for to be constitute a contract, that is lawful consideration. Consideration refers to any benefit or advantage moving from one party to another party. A contract without consideration is not valid. So there must be a consideration. And next, fifth requirement is lawful object. The object sought to be achieved by a particular agreement should not be unlawful or illegal, namely immoral or opposite to the public policy. It should not oppose the public policy, or immoral, illegal objects are not constitute a contract. And the last one, sixth one, the agreement must not have been expressly declared to be void. The agreement, if declared void expressly, it can never be enforced by any court of law. For example, agreement in restraint of marriage or agreement in restraint of trade cannot be valid contracts. The Indian Contract Act nowhere prescribes that the contract should be made in writing or in a particular format. There can be an equally binding contract between the parties on the basis of an oral agreement unless there is a law which requires the agreement to be in writing. A person who signs a document which contains contractual terms is normally bound by them even though he has not read them, even though he is ignorant of the precise legal effect in view of a clause in the contract having formed one of the stipulation in the contract along with the others. This is about, or these are the essential conditions or essential requirements for a valid contract. Thank you.